Yes, you can appeal a restraining order in Ohio. Typically, though, a restraining order is known by another name, and that's a domestic violence civil protection order. Those are generally heard in front of magistrates, not the judge. So the first thing you have to do if you disagree with the decision is to object to the magistrate's decision. There's a very tight time period to object to a magistrate's decision. That's typically 14 days from the time that the magistrate timestamps the order. So it's really important that you look at the timestamp and have an attorney representing you throughout the process so that you don't miss the objection period. Once the objection period is completed, it then goes to the judge. The judge will then review the facts and make her own independent determination as to whether or not the domestic violence civil protection order should have been granted. After the judge makes the decision, it's at that point that you can appeal to the Court of Appeals. Now, this is always a lengthy and time-consuming process. From the time you have the hearing until the time you get to the appeal could be approximately 3 to 5 months. Once the Court of Appeals gets a case, though, it could potentially be a year or more before you get a final decision dispensing your case. Now, does the Court of Appeals end it? Of course not. At the Court of Appeals, you then have a time period of up to 45 days to take it to the highest court in the state of Ohio, and that's the Ohio Supreme Court. The Ohio Supreme Court is not a mandatory appeal, it's a discretionary appeal, meaning they don't have to take every appeal that comes their way. So yes, in Ohio, domestic violence civil protection order can be appealed.